no contact, no phone calls, no letters, no social media contact. You see her Taco Bell, you're eating Burger King, don't have your friend call her and see how she's doing. She tracks you down and begs to meet for coffee. She can't change this order, only myself or somebody else with a rope. Clear enough? Is it not an element of the crime?
It is.
And doesn't each and every element of a crime have to be proven beyond a reasonable or beyond probable cause today? Because I think she got you.
I don't think so, Judge. I've never heard of it.
It's a probable cause hearing.
Well, I would ask the court to take judicial notice over their own records of the defendant.
And
Release.
you got that?
Yes.
All right. And that court date next week is live in my courtroom.
Yes, sir.
All right. Any questions for counsel before we let you go?
No.
All right. Good luck.
Thank you.
And that brings us to Brown. Go ahead, counsel.
Neighborhood, the conversation was right by name, we have Mr. Brown, who stands to my right. Mr. Brown, please state your name.
Nicholas James Brown. Thank you.
Mr. Brown is here for probable cause conference. An offer has been made, and I have not had a chance to review the discovery that was sent.
Bump it out to the same date? Which was what? 26th?
6 at 9:30. Judge Patton.
9:30, was it? All right, and bond will be continued on this file.
Thank you.
All right, Mr. Brown, just give us a minute. We'll get you a paper notice. That it, counsel? Thank you. Have a great afternoon. Brian, is it Thiessen? Tyson, come on up. All right, so I've got two files. I've got a fail to yield for emergency responder, and I've got equipment violation. My understanding is you're going to plead responsible to an added charge of impeding traffic, and both charges would be dismissed, correct?
Yes.
Okay. And we've already got $400 in bond money. Is that correct?
Yes.
On the two files? Okay. All right. All right. Anything you want me to know before I decide what your fines and costs should be?
No.
All right. So I'm going to dismiss the equipment violation and that bond will be returned to you. That's the 150 bond. And on the fail to yield, I'm going to reduce that to an impeding traffic and apply the bond and close the file. You understand that?
400 would go to the.
250 I'm going to keep on the one file. 150 is going to go back to you.
Okay.
Got it? Any questions?
No.
Go downstairs, hang out by the cashier, and they'll call your name when they're ready for you.
All right.
Go right to the cashier.
Just walk slowly and go to the cashier and she's all ready for you.
Okay.
Thank you.
Thank you. Morning, Judge.
Morning, counsel.
How are you?
Good. What do you got?
Ms. Staples?
Staples?
Yeah.
And are you ready?
Yes.
Come on up. Counsel, your appearance, please.
Good morning, Your Honor. Paul Stavlin appearing on behalf and with Ms. Staples, who is standing to my right.
Do you have a plea agreement?
No, Judge.
All right, what are we doing today?
I'm asking the court to give us another pre-trial date. We need to do the agreement. Regarding the agreement, Ms. Staples reviewed it.
Done.
Yeah.
How far out you want to go? Pick a Wednesday.
But I'm wondering if we could have 6 weeks,
Sure.
because some things that, Mr. Muhammad and I want to do.
March 19?
Fine.
Give me a time.
March 19th.
March 19th.
Morning.
19th, do you want early morning or later morning?
I would rather have early morning.
8:45.
Joe,
Yes.
see that sunlight hitting that next guy's face?
What I'm about to
So that's March 19th, 8:45.
Yep. All right, counsel, I'm assuming your client is a good candidate for a personal bond.
Yes, she's full time. Never been in trouble.
Where are you working?
Yeah, imagine that.
And, this is simple. But from the first time that she and I met, it was.
It's been a while.
And we've stayed in contact, just waiting for the process.
Good.
Play out.
Good.
See today.
Okay, sure. All right, Ms. Staples, I'm gonna put you on a personal bond. First condition's pretty obvious, stay out of trouble. Second one's pretty obvious, be in court on that court date. Third one, do not purchase, possess, or consume any mood altering substance unless you've got a doctor's prescription. That means no alcohol, no marijuana. Got it? Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court in the amount of $1,000 if you screw up on bond? Questions? Counsel, anything else?
No.
If you want a paper notice, stick around for a minute. We're gonna get you a paper notice. All right? Thank you.
Thank you, Judge.
You guys got something ready?
Yeah, it is up to Judge Orange.
This one? Oh, pre-hearing. All right. All right, you are Mr. Aurora? Counsel. Okay. And how do you say it? Aura? Auraha. And you have authority to take care of this matter today? Looks like you're pleading on her behalf to impeding traffic and dismiss the traffic control device.
That's correct.
Okay. Did you guys negotiate any fines or costs?
No, no.
All right. Fines and costs, $180. How much time you need, counsel? How much time you need to get her money? Okay, done. Have a good day.
No, no.
25 case.
Yes, Judge.
Yes, yes. I don't have a 25 case. I got a December 24 and I got a,
No, the 25 case is in the case number.
oh. Got it. Yeah, and how did we do? Oh, okay, that's why it came in 2025, but it's a 24 incident date.
Yes.
All right. All right, so let's get appearances on Leslie Morgan.
Morning, Your Honor, Patricia Mandrack for the people, the 84088.
May I please report? On my left, the 5634 for the record, Leslie Morgan.
Thank you. Counsel, would you waive formal reading on the 12/21/24 incident?
You wait for reading.
I'll enter a not guilty plea. All right. So we're gonna adjourn a pretrial out till March 19th?
March 19th.
If they're coming back to us, they
Yeah.
want 6 weeks, just for a pretrial, yes.
March 19th?
I'll be in a trial that starts that Monday.
How about the week after? 26th?
Early morning or later morning?
You said which day? I'm sorry.
March-
26th.
We have starting at 8:45 all the way to 10:30.
9 o'clock, please.
And but I was trying to request that meeting with Ladies, President's Day. Wait for that final, for that pre-trial.
Done.
Thank you.
All right, so on the April 10th incident date, we'll just continue bond. Let's talk about bond on the newer incident.
Judge, in this case, for the malicious use of telecommunications device case, I am requesting that I am going to leave the terms of bond at the discretion of the court. I would ask that another no contact order be entered. And I would ask that the court reiterate to the defendant that it's in complaining witness contact, and if have no contact with them.
Okay.
Mr. Morgan does understand that I have contact with her. However, she does, and he's showed me her, and I've showed that to the prosecutor. She does what amounts, in my opinion, to harass him and his wife. 100 calls a day type stuff. And so we would ask the court to maybe monitor her.
She's not under my thumb. She's not under my thumb.
And Judge, I haven't talked to the complaining witness about this.
Right. I think it's ill-advised behavior, but I don't have her on a bond. Yeah. But I want to note for the record that the no contact order, at least according to my records, was entered on December 24th. The telecommunications charge came out of December 21 incident date. So I don't hear any allegation that the bond on the first file was.
That's correct, Judge. If that's, and I can just, if defendant had been arraigned on the before, this conversation would be very different.
Yep. Okay. All right. So what I'm going to do is I'm going to mirror the bond on the second file as to match the first file. No contact, no phone calls, no letters, no social media contact. You see her Taco Bell, you're eating Burger King. Don't have your friend call her and see how she's doing. She tracks you down and begs to meet for coffee. She can't change this order. Only myself or somebody else with a rope. Clear enough? Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court in the amount of $1,000 if you violate bond? That's condition 1. Condition 2 is no other trouble, no new criminal offenses. And condition 3, you got to be in court for March 19th.
Yes, sir.
Agreed? Anything else, counselors?
I believe you said March 19th?
March 19th at 9. Oh, I'm sorry. We talked to 19th and we moved it. Good catch.
Thank you.
Have a good day.
Oh. Okay.
For you and for your client.
Counselor, are we ready on Mullins?
Mr. Mohammed. No. I don't.
How's Miss Henderson today? I said, how's Miss Henderson today?
Yeah.
Wonderful. Are we holding this one?
All right, thanks. Have a good day.
Sit.
Yeah, we will hold those.
Yeah.
I have seen two emails here.
Hey, Ken, you have to be here tomorrow.
I'll be here.
People are on.
Believe me, I always show.
What look you at?
Well, he was worried that you'd try to get out.
I didn't say that. Well, they didn't have to wear leggings under a skirt.
We ready? Mr. Mohammed?
Yeah.
All right. If you two would put your appearances on the record for Mr. Ray Mullins, please.
Good morning, Your Honor. Mohammed on behalf of the people.
Good morning, City Anderson with the Neighborhood Defender Service, P84839, appearing on behalf of Ray Mullins, who's present in the courtroom today. Can you please state your full name for the record, sir?
Ray Mullins.
Thank you. Have a seat, Mr. Mullins. The attorneys are trained to jump up in law school. You don't have to do that. Are you ready, Mr. Muhammad?
Yes, the people called Officer Cozero. Kuzor, my apologies.
Corporal, come on up. Watch your step on my ramp. Raise your right hand. Swear affirm to tell the truth, the whole truth, nothing but the truth.
I will.
Have a seat. You know the drill. Settle in. When you're ready.
Good morning, Officer. Can you please state your full name for the record?
Nathan Kuzera.
Officer, I'm gonna take you back to the day of September 2nd, 2021. Did you work that day? And in what capacity did you work that day?
Road Patrol.
Okay, and who's your employer at that time?
City Road.
Okay, and in what capacity did you work for them?
The Road Patrol.
Okay,
Police officer.
okay, and on that day, did you work by yourself or with a partner?
By myself.
Okay, and did you work in full uniform or modified uniform?
Full.
Okay, and on that day, did you operate a scout vehicle or did you work foot patrol?
Separate.
Okay, now was the scout vehicle fully marked or semi-marked?
Full work.
Okay, and on that day of September 2nd, 2021, did your duties as a police officer take you at or near the location of North Line and Huron River Drive?
Yes,
Okay, is that located in the city of Romulus, County of Wayne?
yes.
What took you to that location?
Let me stop you, Mr. Mohammed. You don't know this, but we do. Which North Line in Huron River Drive?
North Line and West here.
Thank you.
Thank you. And what took you to that location?
Dispatch location. To be an accident.
Okay, and when you made that location, what did you do?
On arrival, I saw. Actually, the step back, it was a reference a green Yukon and a blue Ford Explorer that was involved in the accident. No injuries reported and being reported off the side of the road. Upon arrival, heading west on Huron River Drive, and I got behind the vehicle that was on the westbound side of the road, which ended up being a blue Ford Explorer.
Okay, and you indicated that there was a traffic accident. And did you observe any damage to any vehicles when you made that location?
Yes, there were two vehicles there. The green Explorer, or green Yukon and the blue Explorer. I was very damaged to.
Okay, now when you made that location and you made those observations, what did you do?
First contacted the Explorer.
Okay, now how many individuals were seated in that Ford Explorer?
One in the front drivers.
Okay, and describe the scene.
Vehicle,
The vehicle, anything that you saw.
white male sitting in the front driver's seat, the airbag was deployed. The obvious damage to the vehicle from the vehicle
Okay, now the individual was sitting where exactly?
in the front driver's seat.
Okay, now the individual you observed in the driver's seat, you see that person in the courtroom today?
Yes,
Can you please point to that person and point out an article of clothing that person is wearing?
sitting at the defense table,
Can you please
wearing a
point out an article of clothing?
black sweatshirt.
Your Honor, please let the record reflect the witness has identified the defendant.
No,
Thank you. And so then what happened next?
I asked the driver if he was okay. She tried to reply he was, then asked him for his driver's license, registration, proof of insurance.
Okay, and what happened next?
I could smell the odor, the toxins coming from the person,
Okay,
and I seemed to kind of fumble for his driver's license. That when he's pulling out his wallet, he wasn't able to hand me his driver's license while he was looking for his insurance and registration. I also asked him for his phone number to write down the report. The driver was able to only give me 3 of the last 4 numbers of his phone number.
okay,
Then at that point, I asked him about that. There was only 3 numbers, and driver then stopped and looked at me, stated I'm drunk.
okay. Stated what?
I'm drunk.
Okay. And then what happened then?
Made sure he was okay. Believing that the vehicle was disabled, he wasn't gonna be able to go anywhere. Asked him to relax, stay there at that location. So I go talk to the other driver, find out what happened. Then I was able to talk to that driver, get all their information, return to my car. Wrote down the information I needed from that driver, gave him a business card, was able to clear him from the scene when he was able to drive his vehicle. And then I went back to Mr. Mullins to speak with him.
Okay, and so what did you do next?
At that point, I requested that Mr. Mullins step out of the vehicle,
Why did you do that?
believing he was impaired. The
Okay, what led you to that?
smell of intoxicants from his breath. Fumbling for his driver's license. And telling me that he was drunk, which is kind of abnormal, especially at that time of day. And being behind the wheel of the car.
Understood. And so what happened next?
I asked him to.
Bless you.
Sobriety test. He said he wasn't sure if he could, just walk there, and he was able to exit the vehicle. He appeared to be a bit unsteady on his feet as he walked towards the back of the car. I asked him to step on the back bumper of his vehicle, perform the sobrieties. Excuse me. I asked him which grade he was able to completed, and if he was able to read, he said he understood the alphabet. At that point, I asked him to recite the alphabet and stop at the letter P. He continued to the letter S. And then I asked him again about the alphabet, and he refused to complete any work.
Okay, is that indicative of anything based on your training and experience as a police officer?
Yes, it's not too often that people are actually that honest, but he appeared to be fairly impaired at that point, and I'm unwilling to complete any more sobriety tests.
So besides the alphabets, were any other tests conducted?
I was also able to administer a preliminary breath test at
Okay,
the scene, which he consented to take.
okay, and I believe the results of that is inadmissible in court, so we'll move on. So what about any other tests besides the test?
No.
Okay, and did you recover or observe any items from the vehicle?
Yes, there were, you referred my report real quick.
Will it help refresh your recollection? Officer, with referring to your report, help refresh your recollection?
Yes.
Okay, you can refer to your report once your memory's been refreshed.
Okay.
So go ahead. Has your memory been refreshed?
Yes, there were 2 unopened 40-ounce bottles of Budweiser in a front passenger seat of the vehicle.
Okay, and pursuant to your investigations, did you learn how much the defendant did drink?
When I asked him to step out of the vehicle, I asked him how much he had to drink. He told me he had 4 beers.
Okay, and so what did you do next after you conducted the field test?
I arrested him for suspicion of driving under the influence. Secured the backseat of my patrol vehicle,
Okay, and what did you do after that?
transported him to the Romulus Police Department.
Okay, and what about after that?
He read his chemical test rates and he consented to a blood draw.
Okay, and did you transport him to get his blood draw?
Yes,
Okay, and was his blood drawn?
yes.
And did you observe the blood draw? Okay, and what did you do with that after it was conducted? Was it placed into evidence?
Yes.
Okay, Judge, at this time, I'd move to introduce into evidence the MSP lab report that shows the blood draw results of the defendant pursuant to 76611.
Ms. Henderson, thank you. That'll come in.
No,
Your witness, counsel?
I have a couple follow-up questions for you. You indicated that you were able to observe the blood draw, right?
Yes.
And when you observed the blood draw, you were able to observe the methods that the nurse, I'm assuming.
Yes.
And can you briefly describe what those methods look like?
Mr. Mullins sat in the chair. He, the nurse or phlebotomist, drew 2 vials of blood from his arm. Each vial was placed in the evidence container, evidence box, and sealed prior to leaving the hospital.
And did you do anything, he or she do anything abnormal or out of the ordinary in regards to?
Not that I recall, no.
Okay, we're gonna take you back to the scene of the accident. When you arrived at that time, the cars were already parked, right?
Correct.
So you didn't actually observe anyone driving.
No.
Did you check for any cameras in the area that day?
I didn't check, but I don't believe there are no cameras in here.
Were there any other individuals on the scene that day? Aside from Mr. Mullins, whom you say was at the scene, and the driver of the other car?
That responded to the accident itself. No, I don't recall anybody else being there besides myself and partners involved.
Mr. Mohammed, any redirect?
No, thank you.
Corporal, you can step down, watch your step. Any other witnesses from the people?
No.
Any defense witnesses?
No, Your Honor.
Argument?
Judge, I believe the testimony reflects a question of fact for the prior fact. I believe, based on the testimony of the officer, the defendant himself indicated to the officer that he was drunk, and then also the lab results show that he was only occupant in the vehicle. The officer indicated that the airbags were deployed and this person was in the driver's seat. So I think there's sufficient evidence for probable cause.
Mr. Anderson?
Yes, Your Honor. At this time, Mr. Mullins is currently charged with felony local DUI. To prove the elements of this, third offense, felony OWI, the people would have to produce some sort of evidence that Mr. Mullins was previously convicted of some sort of operating while intoxicated. We didn't hear any testimony today. I wasn't providing any documents in regards to any convictions that Mr. Mullins would have had. Given that information, I don't think that people have met their burden for dismissal.
Judge, it's implied when it's in the complaint, and this isn't a felon in possession charge case where we have to get a certified record of actions. I've never, since I've started as an attorney, as a prosecutor, seen a case where I have to present the prior convictions.
Is it not an element of the crime? Prior convictions?
It's implied based off of the habitual offense notice in the complaint.
Is it not an element of the crime?
It is.
And doesn't each and every element of a crime have to be proven beyond a reasonable or beyond probable cause today? Because I think she got you.
I don't think so, Judge. I've never heard of it.
It's a probable cause hearing.
Well, I would ask the court to take judicial notice over their own records of the defendant.
Your Honor, at this time, I would also note the court did not check the register of action, and there is not, despite what the complaint indicates, there is not a second conviction in 2012 for a conviction for Mr. Mullins, which is why I was ready to see some sort of conviction record of Mr. Muhammad today, but I haven't seen that, and I don't think the court can take, judicial notice of any convictions in the register of action, because there's one conviction in the register of action from the 2022 date.
Well, Judge, I would just point the court to see that in the complaint that we have in front of us, the OWI that occurred on September 8th, 2011 happened after the Fourth District Court. Furthermore, the second conviction that we have, the one that occurred on 07/13/2020, occurred at the 34th District Court. So in this case, both previous convictions were at this very court. So I think the court, if any court can take judicial notice, it would be this court, because both convictions happened and stem out of this court.
Response.
Again, Your Honor, I've checked the register of actions, despite what the complaint says, there isn't a conviction in the register of actions for the 34th District Court noting the conviction in 2012, or any sort of operating while intoxicated. Furthermore, there was no evidence presented today, which is what Mr. Muhammad had to bring to prove today.
Okay.
That there were.
So let me make sure, sorry to cut you off. Let me make sure I understand your argument. I think what you're saying is, even if our computer records show 2 prior convictions, there was no evidence of it today.
Right.
Your turn.
Well, Judge, that's why I'm asking the court to take judicial notice over their own records, and these prior convictions, these 2 occurred in this court. It didn't happen in a year.
No, I got you.
So that's my request.
All right, well, let's see what our ROA says. We have 2? Give me the dates.
I'm sorry.
The dates? Oh, you're just gonna print them out?
That's the first one. Here's the beginning of the second one.
All right, February 2, 2012. Plea of guilty. January 7, 2021, plea of guilty. So I will take judicial notice that our internal records show two separate guilty pleas from Mr. Mullins, just two separate charges. Actually, I'll give you the incident dates as well. One incident date was July 13, 2020. One incident date was September 8, 2011. I'm still not sure you don't have to have evidence of it beyond judicial notice, but I'm going to bind it over and Ms. Henderson can appeal me and tell me I'm wrong. Clear? Anything else? Good luck downtown, Mr. Mullins. We'll get you a AOI date for 2 weeks down the road. But we don't give them a paper notice anymore. So your next court date's downtown 2 weeks from today, 9 a.m. Bond is continued. I'd like the attorneys up here when you're done with your client, Ms. Henderson. Any chance of that getting pled downtown?
Yeah, I'm
Back to a misdemeanor?
put a case note. I could have swore I
He's a Belleville guy. We got a great sobriety court program.
here.
I just took it over January 1. So I'm just throwing that out there for the two of you.
I wish.
You know, I'm cocky enough to think that we do a better job here than what they do downtown, so.
Okay.
I would wonder if we can like keep it here, even though it's too late.
I mean, I'm still gonna write mitigation information once I get over there to have it reduced, so.
Yeah, but if it's still here, I can go to my chief, talk to him face to face, and be like, "Hey, this one." But I'll put a case note.
Okay.
I can't figure out how I would
And
keep
plus,
it
I
now.
would rather keep him here because.
Well, he lives in our venue, so.
Yeah,
I'm
yeah.
assuming if downtown wants to put him in sobriety court, they're probably gonna want him in ours, I would think. I don't know.
Just make that request.
And I'm not saying he's eligible.
No,
I just,
because
the first thing we look at is where he lives, right? If he was living in Pontiac, we wouldn't even consider it.
No, and they're older and stuff as well. The only reason I didn't unilaterally reach out to my supervisors because we had no CCH in our system for this case.
I'm not blaming anybody for anything. I'm just throwing that out there because we're trying to build up our docket on the sobriety court and this guy needs help, obviously.
Yeah.
Okay, all right. Good luck downtown. Let me know, Ms. Henderson.
We have Mr. Starling Ellis.
I'm ready. We holding that one?
I think he's here.
Oh, I forgot that. Mr. Muhammad, let's talk about Mr. Sterling, who's in federal prison and Huron didn't go get him. Not that anybody thought they would, but.
Correct, Judge. So I was informed that the defendant is in federal custody. And my understanding is he has a release date, I think in April. And so I would request that we just adjourn it to that date. To a date in April.
Do you know what date? Too early, it's not here.
When I looked, it was, I think, towards the end of April, this is beginning of May.
So maybe the first court hearing in May, is something state.
Are you talking for just another piece, or for another exam?
Yeah, we could just keep it as an exam, because it's gonna be the same defense.
We have May 7th. His mom is on, if you want that picture.
Oh, yeah.
Miss Ellis is on as an observer, if we can ask her if she knows.
Oh, Miss Ellis, can you activate your camera and or microphone, please? This is Mom.
Yes.
Okay.
Miss Ellis? She, does he really know? Is he?
He had an Illinois address on our file.
Oh, there's Miss Ellis.
Miss
Hello?
Ellis, can you hear me?
Yes.
Good morning.
Good morning. How are you?
Excellent. I've got the prosecutor here and your son's attorney, Miss Henderson. Can you, if you know, can you tell me when your son is supposed to be released from the federal prison?
April 25th. It was
Thank you.
originally 27th, but because it's a weekend, he gets out on 25th.
All right, so what date would you propose? So, just, Ms. Henderson, you want to go with a PCC or just keep it with an exam?
Um.
I don't really care.
Maybe a PCC to be safe.
Yeah, so I can, once he's released, I can contact, him to make sure he gets transportation.
Okay. All right, so we'll go with a probable cause conference, May what?
May 7th,
Time?
we can do 10 a.m.
Ms. Henderson, 10 a.m.?
That works.
All right.
Can he, if he's out of state, can he?
Mom, where's he gonna be
Yeah.
after he gets released?
He will be with me. He will stay with me in
Where's
Bellwood.
that at?
Bellwood, Illinois.
Okay, all right. So is that the 734 Bellwood apartment GE?
Apartment 2E. He used to stay in GE. Now he's 2E.
Thank you. And how about a phone number? Oh, counsel, you've got mom's number? All right. All right, so what I'm gonna suggest is you be in contact with Miss Henderson.
Yes.
All right?
Yes.
Anything else?
No.
Thank you.
Good luck, Mom.
Thank
Have a
you.
nice day.
You too. Bye-bye.
Thank you, Miss Henderson.
Was that the last?
No, you still have, well,
Yeah,
I is here with the second court attorney and,
Larkins.
Okay, thank you.
I'm ready.
Okay.
You as well, counsel. Liberty. Files for Doe and Liberty, those are notes.
Mr. Liberty was on Zoom. I was chatting with him. And he said he wanted to apologize for meeting late, but they were just setting up their meeting in 3 months. Just let the judge know I was.
Back row, are you witnesses?
So he's the victim and then.
Okay.
the victim advocate.
Okay. All right, let's get started.
The people called Kelly Massey.
Ms. Massey, all the way up front. All the way up here. Watch your step on the incline ramp right here and raise your right hand. Raise your right hand. You swear or affirm, tell the truth, the whole truth, nothing but the truth?
I did.
Have a seat right there. When you're ready, Mr. Muhammad.
Good afternoon, Ms. Massey. Can you please restate your full name for the record?
Yes, my name is Kelly Massey.
Okay, Ms. Massey, I'm gonna take you back to the date of November 24th, 2024. Were you at or near the location of 16857 Howick Lane? And for the record, Howick is spelled Hawick.
Yes, I live next door at 16869 Hollis Lane.
Okay, and is that located in the city of Romulus, County of Wayne?
Correct.
Okay, did something happen at or near that location that brings you into court?
Yes,
Okay, how did that begin?
on that day, I opened my window downstairs, window next door,
So where were you?
in my living room.
Okay, at your home?
Excuse me?
At your home?
Yes, inside of my home,
Okay,
in my living room. I opened my window and I looked out and my lights that I have in the ground and around the perimeter of the mosque, the lights were broken. That was not the first time the lights were broken because she's broken them before, but I noticed that day more lights were broken. So I just shook my head. I knew it was exactly what was going on. I went upstairs as I was ready to start work that day at 1 p.m. So it was time for me to get in the shower and get myself ready for work.
Hold on. Something's wrong with our equipment.
Stopped. Yeah. I'm gonna stop this and start working. It's saying what she previously said.
But, I spoke of this.
No, equipment for some reason is just replaying. Stop, it's not recording, it's just replaying. It's replaying in my ear. I did. Yeah, let me try it now, turn it up again. Let me turn it on. Okay, good. All right. Listen. Okay, talk.
Okay, is it testing, recording?
Yep, perfect.
Okay, all right. Sorry about that, Miss Massey. So Miss Massey, I think you said you were headed upstairs to get ready for work.
Yes. So I proceeded upstairs to my upstairs bathroom to get in the shower and get ready for work. After I got out of my shower, I'm in my bedroom getting dressed. And I just happened to glance out the window. And that's when I see Sheila Marie Larkins in a black bra and a red plaid schoolgirl skirt, holding her barbecue grill, running full throttle charge through the yard toward my windows, my downstairs window. That's my little window. And I yelled out, I said, "What are you doing?" And she said, "I will tear this whole effing yard up." And she took the grill, and at that time, I seen her just running, and I started coming downstairs to go to my door, because I thought she was going to bust the window out with the grill. When I got down there, she took the grill and she threw the charcoal ashes all across my window. And as I'm coming outside and I'm walking to her over to her towards the main part of the sidewalk, more towards her side of the yard, that's when her boyfriend was standing there in the matching pajama pants to her skirt and his robe. And then she opened the door and she pointed the gun directly towards my face and between my head and my neck and said, "Bitch, I will shoot you." I had my cell phone in my hand to film because she's never pulled a gun. But she's just been antagonizing so much. I had my cell phone with me to film because I knew that I needed to show the police this. And after she did that, and I guess she realized that she was being filmed, she ran in the house. The boyfriend was still standing there. I said, "This has been going on for over 2.5 years. He's just standing there not saying anything." She ran back in the house and put the gun down. When she came back to the door, she opened the door, she ran out. She picked up a rock that was by her porch, about the size of my head. She took the rock and she threw it at me. When the rock did not hit me, she then picked up a Santa's mailbox, a metal Santa's mailbox with
A what mailbox?
a metal Santa's mailbox
What's a Santa's mailbox?
Yard decoration.
Oh, okay,
for Christmas,
okay,
for Santa Claus. It was porch decor. She then picked that up. It had a candy cane handle about that big. And she took that and she threw it at me. It did not hit me. When she didn't hit me with the metal Santa box, she then grabbed the barbecue grill top from her grill that she had already thrown toward the window. And she threw the barbecue grill top at me. And it missed. I blocked it with my hand. At that point, she has come further from her porch, so she's now on the common sidewalk. At that point, she ran out of things to throw. And then she came, she had her hands up, I put my hands up, and then it was mutual combat.
understood. Now, the firearm that was pointed at you, can you describe it?
It was black. I can only see the front of it. I never got a side profile of the gun, because by the time she came and opened the door, she had it pointed directly at me.
Okay, can you describe what kind of gun? Was it like a long gun, a shotgun, a handgun?
It was a handgun.
Okay,
It was a handgun, but she had it in her hand. but I only seen the front profile of the gun.
Okay, so black handgun,
Yes,
okay. Now, this individual that you mentioned, Ms. Larkins, the person who pointed this firearm at you, do you see this person in the courtroom today?
yes.
Can you please point to that person and point out a piece of?
Well, I can't tell you because I never seen her with that hair. The hair that she had was blue dreads. The natural hair is blue dreads, and I've never seen her with glasses on.
Okay, so, but do you see that person in the courtroom today? The person who,
Pull the gun?
yes,
No, I seen a person that had gray roots with blue dreads, no glasses.
okay. Judge, I would request for the person sitting at the defense table to remove their glasses and maybe that assist in identification. And to just move their hair away.
No objection, Your Honor.
Judge,
What's your objection? We've asked her to show her face.
She is showing her face. Her taking her wig off is,
That wasn't the question. The question was, could she move her hair off of her face?
and I never said it was a wig, but I'm assuming based on your statement, it is a wig. I just asked it because for the record.
Counsel, I don't think I don't think it's asking too much to be able to see her eyes when there's an identification at issue. Thank you.
Okay, take a look in the courtroom and see if you can, if that person.
That's the one with our face in the yellow jacket.
How do you know that?
I can see the face profile now without the glasses. And I'm pretty sure that there's blue dreads or she may have dyed them with their dreads under that wig.
Okay, Your Honor, purposes, I respectfully request the court.
I'll note there's been an ID.
Know that there's a- okay. And when this firearm was pointed at you, how did you feel in that moment?
I felt like my life was hurting.
Okay,
I was scared. My heart was beating.
okay. Nothing further.
Counsel, your witness.
good afternoon, Miss May. Is it Macy?
Maxie, MASSEY.
Okay. So, you just testified that, Miss Larkins threw things in your French oven.
No, she threw those things at me. She threw the rock, she threw the mailbox, and she threw the barbecue.
We're not that far. You said you got out of your shower and you looked outside and Miss Larkins was coming at your front door, correct?
No, she was coming at the living room window
Okay, living room window, with an object,
with the barbecue grill,
a barbecue grill.
her barbecue grill.
Okay. And you just testified that when you were outside, you saw Miss Larkins pointing a gun from her house.
When I was outside, I saw Ms. Larkin pointing a gun at me from her doorway.
From her doorway inside of her house.
No, she had the door open, she was standing in the doorway, but the door was open.
Okay, but was she in her house?
She was standing on the, I guess, the bottom of the door. That's where she was standing,
In her doorway?
in her doorway.
Okay. Did you try to get in Miss Larkins' house?
Absolutely not.
Did you tell, Miss Larkins during that argument to go get your gun?
Absolutely not.
You just testified that you feared for your life, correct?
Correct.
Okay. But you didn't leave, correct? Meaning you didn't go back in your house.
I was standing on the common part of the sidewalk.
Did you go back in your house? Yes or no?
No, I didn't have an opportunity to.
Okay, so you You just testified that Miss Larkins closed her door and went and put the gun away, correct?
Correct, yes.
Okay, so in that time, you didn't go back in your house,
At that time, I stood there talking to her boyfriend who was standing there.
but you did not go back into your house, yes or no?
No,
Okay, then Miss Larkins came back out without that gun, correct?
she came back out.
Okay, and you and Miss Larkins then proceeded to fight, correct?
No, I was standing there. I thought my phone was still finished. So I was still standing on the common part of the sidewalk. She came out of her house after she put the gun in the house. It was only seconds. So it wasn't like it was minutes went by, there was seconds that went by. She opened the door, ran out in her bra, in school girl skirt with no underwear. Bent down, picked up a rock with the side of my hand, threw the rock.
Okay, so again, you had time to speak with Miss Larkins' boyfriend, correct?
Can you repeat that?
You had time to speak to Miss Larkins' boyfriend, correct?
Yes.
Okay, but you didn't go in your house, correct?
No.
Okay. Miss Larkins allegedly threw things at you, correct? Rocks and signs that was in the yard, Christmas decor, correct?
No, she threw a rock, she threw a metal Santa's mailbox. Then she
That
threw
is Christmas
her,
decor.
then she threw the top to her barbecue.
Okay, it's still Christmas decor. Then after that, the two of you had, got to fighting, correct?
Correct.
Okay. And then,
She came over.
Hold on. Lady, counsel, really? You need a minute?
no, you're not.
You just answer the questions that are asked. Don't volunteer. Question is,
After the fight, did you go back to your house?
Yes,
Okay. And their police came and spoke to you, correct?
correct.
Did officers tell you that there was a 911 call of you trying to get in her house? Miss Larkin's house?
No,
Okay, no further questions. Your Honor.
Mr. Muhammad,
Very briefly. How long have you been neighbors with Miss Larkins?
I moved to 1689, well, excuse me, 16869 Holiday Lane on December 28th, 2022.
So approximately 2 years prior to this incident?
Correct.
Okay. And during that time, how many times would you say, if you know, are you very interactive with this neighbor?
No, from the first time I moved there was pounding on the wall in the living room. We found the strange, my movers came concerned, like what's going on, they left early. As that happened, it continued to get more frequent with the beating on the wall that happens mostly in the bedroom. It happens through the night. After it happened for so long, I then contacted the owner of the condo to ask whether there were any issues with the prior tenant that lived in my residence.
Okay, I guess my question is, have you seen this defendant before?
Yes.
Before this interaction?
Yes,
Okay, and so are you familiar with her face?
yes, I am.
Okay, and that's the same person that individual is, you're the same person that we have in the courtroom?
Yes,
Okay. All right, nothing further.
any recross?
No, Your Honor.
Ma'am, you can step down, watch your step on my incline ramp.
No further questions.
Thank you. Any defense witnesses? Ms. Tucker?
No defense witness, Your Honor.
All right, I'm ready for argument.
Judge, I'm gonna motion for a binding where I believe the testimony reflects the question of fact for the trier of fact. With her actually rebuttal.
Ms. Tucker, argument?
Yes, Your Honor. I object to the bind over on this, case of, Your Honor. Miss, Macy didn't fear for her life. Miss, Larkins did not step out of her house, Your Honor. Miss Macy stayed outside and waited till Miss Larkins came out in without said gun to where they then proceeded to get into a fist fight, Your Honor. So we object to the bind over.
Mr. Mohammed.
Judge, I believe the testimony by the witness was that she didn't feel in fear. He indicated that there was a gun pointed in her direction, and I believe the testimony reflects a question of that.
And that was the only testimony put in front of the court. Bound over. AOI 2 weeks from today, 9 a.m. Bond is continued. Good luck downtown, ladies. Do we know if Mr. Bryant is here? Oh,
I believe all,
do we know if the attorney's here?
that I don't know, but I do have all.
The attorney would be Margolis. No shows.
We got everybody here but the defense attorney on this.
What a surprise. You got a phone number?
I think you're good. I was just gonna say, I knew you was gonna get on that.
She didn't get rattled at all. But she objects to the bond with no testimony.
I didn't hear what she said. Check what she said.
She's trying to talk over me.
She's very, like, she should be getting excited like that. She's an attorney.
Well, just get excited if you want to. Just don't get excited with, no.
Hi, this is Heather calling from 34th District Court Judge Oakley's office. Is Mr. Margolis there? The 34th District Court, you had an exam at noon today in our court at 34. Xavier Bryant.
Mind about these two? It's enlightening you.
Yeah, December 30th, you appeared on Zoom and you requested to have today as an exam. Did you speak to your client? His name spoke to his client.
Oh, God. Bring Brian in. I'm sorry? Bring Brian in, please. Okay.
Let's bring the prisoner.
He didn't write it in his book, Judge. So what do you do?
We're gonna have to adjourn it.
Right. We have next week at 1 o'clock.
How's it going? Make sure Muhammad's coming in, would you? We got him. The attorney's on the phone. He's at his office. He forgot to be here today.
You like Muhammad now?
Yeah. We gotta pick another date.
That's, yes, February 12th at 1 o'clock at the 34th District Court in Romulus. And your client is still in custody, so you know. Thank you. It's not, you don't have to tell us you're sorry. You need to contact your defendant. All right, thank you.
Would you like Muhammad in here, Judge?
Yeah, we're ready. Mr. Bryan, just have a seat, sir.
He's aware of the notice, it's just not, it's never wrote it in his book.
Mr. Muhammad, your appearance on the People versus Xavier Bryant, please.
Good afternoon, Your Honor, Mohammed on behalf of the people.
All right. So for the record, this exam date was scheduled on December 19th. Well, Mr. Bryant and his attorney were present.
December 30th.
Oh, December 30th. Yeah, at our last PCC. Heather just called the attorney's office and he forgot to put it on his calendar. So we're gonna have to reschedule. Are you available, or whoever your witnesses are they available next Wednesday? We've given counsel a time slot next Wednesday at 1. I just want to make sure your witnesses are present.
You show me the bill, Judge.
So the defendant attorney Brian. The court wants to make sure that next.
I just want to make sure you guys aren't in training or on vacation or anything next Wednesday. You're all available?
Yeah.
Gang's all here? Okay. I know where you're at. Sorry. So we'll see you next Wednesday. All right. Questions?
Nothing will be moving.
Would we want representing?
No. Your attorney's not here today because your attorney forgot to put it on his calendar.
I would like, no counsel. I haven't a lawyer that I take the part.
You mean you're gonna hire somebody? Have that person file an appearance yesterday. I mean, have them do it soon. All right?
Should we
All right.
still have a set for an exam if that's?
Let's leave it there and then the new new attorney can contact you if that's a problem.
Oh,
Right.
huh?
We got to see an appearance before we do anything.
Oh, yeah.
Yeah. So have the attorney you've hired, have them file an appearance so that everybody in the system can talk to them as your attorney. All right?
I'm hearing
I hear you.
You know,
All right.
whether yes, you sure that I don't have a specific name yet, someone from that company instead of the
Okay. Who'd you just talk to?
Margolis was appointed.
From NDS.
Not, yes.
He's not.
He was appointed through the.
Okay.
Indigent.
All right. All right. It wasn't Mr. Margolis. That's not the name?
rather,
Yeah. That's the guy that you talked to Margolis back in December, right? Okay. So that's who we just talked to that's not here. So if you got somebody else that's coming in, they got to file paperwork. And then he can legally talk to them about it. All right? All right. We'll see you next week.
thank you.
All right. Sorry, guys. Be safe.
Sort of.
Who knows? Yeah. That just kills me.
And
I mean,
he hasn't spoken to his client since.
Yeah. Yeah. And he's gonna, and they're making good money.
In this courtroom moment, the judge addresses the issue of a no-contact order between the defendant and the complainant. The defense explains that the complainant has allegedly been calling the defendant many times a day, while the prosecutor notes that the complainant is not under bond conditions. The judge clarifies that regardless of who initiates the contact, the defendant must still follow the court's no-contact order. The judge then mirrors the bond conditions on the second case to match the first. No phone calls, no letters, no social media contact, and no indirect contact through friends. The defendant is warned that if the complainant approaches him, it still does not change the court order. Only a judge can modify it. The judge sets the bond at $1,000 and orders the defendant to stay out of trouble and return to court on the scheduled date. Question: if the other person keeps contacting the defendant, should the court change the no-contact order? If you enjoy real courtroom moments like this, like the video and subscribe for more courtroom content.